Your Honor, this is the case of Harley Davidson versus Gotham City Department of Housing Preservation and Development. All counsel witnesses are present, are ready to proceed.
Thank you. Good morning to all. My name is May D'Agostino. I am one of the Article 3 judges here in the Northern District of New York. It's always my pleasure to see these outstanding high school students compete in the state final. I'd like to begin with a couple words about this morning's competition. We have the two best teams in the state of New York here today. Both teams have worked through regionals and have worked very, very hard to get to this point. At this level, for a presiding judge like myself, with the talent that is in this room, a decision is often made at the end by literally millimeters. We begin with the top two teams in the state, and we end with the top two teams in the state. Yes, I will vote for a prevailing side today, but I want to make perfectly clear to everyone that there are no losers today. We have the most talented two teams in the state of New York. So at the end of the trial, everyone needs to remember that. I was a trial lawyer for 30 years. I won some cases that I felt I probably shouldn't have won, and I lost some cases that I felt I should have won. What has gone on throughout the state is a reflection of what goes on in a real trial lawyer's life, and that will be the same today. Both teams, win, lose, or draw here today. There won't be a draw because I'm not allowed to have a draw. But both teams need to leave this courtroom today with your heads held very high. You made it. You made it to the state championship. So please, everyone, remember that. Is the petitioner ready to proceed?
Your Honor, before we proceed, we have some pretrial matters.
All right, go ahead.
With regards to marking exhibits, if Your Honor agrees, we would suggest doing it during the course of the trial, as it's simplest and saves time, and we haven't had a chance to confer with opposing counsel about which exhibits they plan to use.
Your Honor, we agree with this.
Very good.
Your Honor, and also your permission to use the well of the court, or would you rather have us use the mic?
You may use any area of the court that you feel comfortable with.
Before we proceed, I'd like to introduce my team.
Please.
I'm Ruth Kurtz, along with my co-counsel, Brianne Moore.
Good morning, Your Honor.
Good morning.
And Brielle Bowman.
Good morning, Your Honor.
We represent the petitioner, Harley Davidson, in this case.
Could each of you spell your last names for me, please?
Your Honor, for your convenience, we have a roster.
That would be terrific.
Thank you.
Okay, thank you.
Thank you. Anything else, counsel?
We're ready to proceed, Your Honor.
All right, how about the respondent?
Good morning, Your Honor. We'd also like to introduce ourselves. My name is David Hongs, and I, along with my co-counsel Cecilia Beyer and Catherine Yang, will be representing the respondent in today's proceeding. We also have a copy of our team's roster, if Your Honor would like.
I would like that. It's very helpful. Thank
May I
you.
approach the bench?
Yes, you may.
I'm also providing a copy to opposing counsel.
Thank you.
Additionally, Your Honor, we do have one pretrial matter to attend to. We move to constructively sequester all witnesses with the exception of Harley Davidson, who is the sole party that will be testifying today, pursuant to Mock Trial Rule 11F.
Thank you. All non-party witnesses will be constructively removed from the courtroom.
Thank you, Your Honor. With that, we are ready to proceed.
Thank you. All right, the petitioner may proceed.
May it please the court. The willful blindness of the respondent in this case blocked my client from rightful succession to a rent control apartment. Did they act reasonably in doing this? No. Did they act based on established facts? No. They acted in an arbitrary and capricious manner to achieve a predetermined outcome because they did not like my client. Nothing in Harley's life has come easy. Before his great aunt Barbara Stone welcomed him into her two-bedroom rent-controlled apartment in 2016, he was adrift. But all that changed when he found a stable and affordable place to stay, a home where he lived his family with his great aunt. Around the same time, Harley got engaged to his fiancée, Sage Wisner. Like any couple looking to their wedding, they aspire to a lovely honeymoon and moving in together. Harley will tell you how he took care of his aunt for over 2 years, living with her in the West Huron Street apartment as his primary residence. He will tell you that after she died on March 15, 2018, he learned that she had submitted the required documentation for him to remain in the rent-controlled apartment. The evidence will show, Your Honor, that after Aunt Barbara's death, when my client applied to remain in this apartment, he was inexplicably rejected by the respondent. He will tell you how he was never given any notice, hearing, or opportunity to respond. Due process required by Gotham City's own regulations. Instead, their decision was based on cherry-picked information contrary to the facts. After my client applied, the department assigned to investigator Blake Wards to verify whether my client had lived in the apartment for the required 2 years. The evidence will show this investigation was anything but a search for the truth. Mr. Ward simply decided my client did not deserve an apartment. When you hear him testify today, ask yourself, did he ever interview my client? Did he ever give him any opportunity to provide his own evidence? You will learn that he did not. Instead, Mr. Woods interviewed a friend of his, Hayden Neal, my client's parole officer, who had no first-hand information about where my client lived, but speculated that he lived with his fiancée, Sage Wisner. Instead of interviewing Sage Wisner, Mr. Ward chose to interview Rivers M, who doesn't know much about the situation and who clearly doesn't like my client. Then when Finley Adams, the longtime neighbor right across the hall from Harley, provided contrary facts, Mr. Ward belittled and intimidated her, and even discounted her testimony. Documentary evidence available to the department also failed to provide any rational basis for their decision, and in fact is contrary to it. You will learn that the respondent ignored Ms. Stone's sworn statement that my client was a family member who had resided with her for over 2 years. Much will be made today of the fact that in some past situations, Harley gave out his fiancé's address as his own. The evidence will show this is just a smokescreen. The rent control regulations only require my client to reside in the apartment for 183 days a year. Intermittent absences to spend time with his fiancée or otherwise don't change the fact that Harley Davidson always intended to return to the West Huron Street apartment and that it was and remains his primary residence since 2016. Your Honor, the decision of the respondent was arbitrary and capricious because it violated basic due process and was based on willful blindness, not facts. At the close of this case, I ask that you find for my client. Thank you.
Thank you, Ms. Moore.
May it please the Court. Your Honor, today we are here to determine whether the decision made by the Department of Housing, Preservation and Development, or DHPD investigator Blake Ward, was arbitrary and capricious or rationally based. To render this decision, we ask that you consider the actions taken by Harley Davidson and how they directly influenced investigator Blake Ward's interpretation of the facts. Now, Your Honor, we are not at a trial focusing on disputes concerning whether Davidson lived in her aunt's apartment. Instead, we are in Article 78 proceeding, in which the central issue is to determine whether the decision made by wards was arbitrary and capricious or rationally based. We assert that in the end, Investigator Ward's decision was reasonable because it was supported by 3 actions. First, Davison provided his address to be that of his fiancée at Civics Avenue to the court during his arraignment in 2016. Second, Davison identified this same address as his own to the probation department a few months later. And third, Davison identified this same address as his own on his aunt's death certificate in 2018. Now, consider the combined effect of this. Davison provided this same address over the span of several years, demonstrating a consistent pattern that Investigator Wards had to take into consideration. Now, as you hear the details of these 3 events, in which Davison provided his address to be that of his fiancée at Civics Avenue, consider whether it was reasonable for Wards to assert he did not live with his aunt at West Huron Street. We anticipate that the petitioner will concoct elaborate explanations for each of these instances. They will likely assert them to be isolated events or accidents, when in actuality, they establish a consistent pattern that functioned as a rational basis for Wards' final decision. Pay attention to the testimony of Investigator Wards, who will relate the diligent steps he took in his pursuit of finding the truth. Listen carefully to the conclusions he drew when visiting the aunt in Miss Barbara Stone's apartment, and how his observations there were backed by documentation. He also conducted several interviews in which reliable people corroborated what he had previously learned. You will hear from the aunt's nurse, Rivers Ed, who had been at the apartment every day for 3 years, and had direct knowledge as to whether Davison was a mere guest or a permanent resident. You will also hear from Davison's probation officer, Tatum Lee, who met regularly with Davison for 2 years. Clearly, the compilation of witness testimony, documentary evidence, and observations pertaining to the state of the apartment at West Huron Street led Wards to a single reasonable conclusion. Davison did not reside at his aunt's apartment for the 2 years required for eligibility. Now, in contrast to all of this, the petitioner has relied on witnesses with problematic biases. Finley Adams, the next-door neighbor, as you will hear today, has grown much too attached to Davison and will say anything to ensure that he lives next door. Sage Weisner, the petitioner's fiancée, has lied to the court in the past on Davison's behalf. And as for Davison, the petitioner himself, well, consider how the financial situation of both him and his fiancée could be affected by a ruling in their favor. Your Honor, the petitioner has the burden of proof to show by preponderance of the evidence that the decision made by Wards was arbitrary and capricious with no rational basis. At the conclusion of today's proceeding, based on the actions of Harley Davison and all the other contributing facts, evidence, and testimony, we will ask that you uphold the decision of the DHPD. Thank you.
All right, thank you, Ms. Meyer. Is the petitioner ready to call the next witness?
Yes, Your Honor. The petitioner calls Sage Wisner to the stand.
Step into the box. Your Honor, the witness is deemed to have been sworn.
Thank you.
May I proceed?
Yes, you may.
Good morning. Could you introduce yourself to the court?
Good morning. My name is Sage Wisner.
What is your educational background?
I received my bachelor's degree in mathematics from Cornell University and also my master's in accounting from NYU Stern Business School.
Did you receive any licenses?
I am a certified public accountant and I'm licensed to practice in New York and in Nirvana.
Where did you begin your career?
When I was about 26 years old, I started working at the firm of Ernst & Young, that's in Manhattan.
What was that like?
It was quite stressful. The hours were extensive, and it was just too far away from where I lived.
So what did you do?
I started working in Gotham, which is also where I live, at Gotham's General Hospital. I still work as an accountant, and I've been doing that for the past 10 years.
You said you work in Gotham. Where in Gotham do you live?
I live on 11254 Civics Avenue in apartment 1010.
Could you describe your apartment for the court?
It's a very compact apartment. It's 1 bed and 1 bath.
Is it rent control?
No.
Are you familiar with the petitioner in this case?
Harley? Of course I am.
How so?
He's my fiance.
When did you meet him?
I met Harley in December of 2015, and we later got engaged in September of 2016.
What does Harley Davidson do?
He works as an artist. He makes some amazing sculptures out of repurposed recyclables.
Does Davidson live with you?
No, he visits my apartment on occasion, but he doesn't live with me.
Has he ever lived with you?
No.
Are you aware if he's ever used your address?
I know that at one point he gave his address to his probation officer, but he always has lived in apartment 110.
Does anyone live with him in that apartment?
He used to live with his Aunt Barbara Stone, but sadly she recently died.
Who is the landlord of his apartment?
The department that manages his apartment is the DHPD.
Are you aware that there's a dispute between the DHPD and Harley Davidson?
Objection, Your Honor. Leading. Counsel is testifying for the witness.
Overruled. You may answer.
Yes, I'm aware of a dispute, and they claim that Harley can't remain in apartment 110.
Do you know the requirements he has to meet to remain there?
Yes, he has to live in apartment 110 with his aunt for 2 years prior to her death.
How long did Harley live with her?
Harley lived with his aunt for more than 2 years.
When did he move in?
Harley moved in late 2015.
And when did his aunt, Miss Stone, die?
Miss Stone died in March of 2018.
How did this affect Harley?
Harley
Would you
was-
repeat that question for me?
How did this affect Harley?
Objection, Your Honor. Calls for speculation as to Harley Davidson's state of mind.
I'm going to sustain the objection. You can certainly ask the witness what she saw, what she observed, but I do think that you're calling for this witness to give the state of mind of Mr. Harley. So if you want to rephrase, you may.
What did you observe after Miss Stone died?
Harley was really broken up when his aunt died.
Objection, Your Honor. This is the testimony which you're attempting to keep out.
Now, I'm going to sustain the objection with respect to the characterization, and the jury will be admonished to disregard it. Again, the witness can testify as to what she saw, heard, that sort of thing, observed.
Yes, Your Honor. Did you know Davidson for the whole time he was living with his aunt?
When I first met Harley, it was in late 2015, and he hadn't moved in with his aunt yet, but he moved in 2 months later.
Objection, Your Honor. Invention of facts. Nowhere in this witness's testimony does he give any date as to when Harley Davidson moved in.
Could you repeat that answer for me, please?
I met Harley in late 2015, and he hadn't moved in with his aunt yet. He moved in about 2 months later.
Your Honor, may I be heard?
Yes.
It is clearly stated within the fact pattern that Harley moved into Miss Stone's apartment in early 2016.
All right, overruled.
Have a minute, Your Honor.
Yes.
So earlier you mentioned you were engaged to Davidson, right?
Yes, I am.
Objection, leading.
Overruled. The call's for a yes or a no. You may answer.
I am engaged.
And you plan on getting married?
Yes, we do, in September of 2020.
When you are married, where do you plan to live?
I'm planning to move in with Harley in apartment 110.
Why is that?
It's a much larger apartment than my apartment, and we'll be married, so it'll be nice to have the space. And it wouldn't hurt to save money on rent.
Thank you. I have no further questions.
All right, thank you, Ms. Kurtz. Cross-examination?
Yes, Your Honor. May I proceed?
Yes, you may.
Good morning, Ms. Switzer. My name is David Hongs, and I'll be asking you a few questions today.
Good morning.
Now, you reside at 11254 Civics Avenue, is that correct?
That is correct.
Your apartment costs you $2,500 a month,
Yes.
and it is not rent controlled.
No.
So you say it's difficult sometimes to make ends meet, is that correct?
Yes, considering my current salary, it is.
Right, and the apartment that you and Mr. Davison are trying to move into, that Miss Stone, is only $500 a month. Is that correct?
That's correct.
And that apartment is rent controlled,
Right.
which means you'll save a significant amount of money moving in with Mr. Davison, correct?
That's true.
Okay. Now, you're aware that Mr. Davison was arrested for petty larceny in January of 2016. Is that
Objection,
correct?
Your Honor, beyond the scope of your act.
Sustained.
Yes, Your Honor. Now, you talked about Harley's residence on direct examination. You're aware that Harley had an arraignment in which the residence issue came up. Is that correct?
Objection, Your Honor, again beyond the scope of your act.
Overruled. You may answer.
Would you like me to repeat?
I got it. Thank you. Yes, I was at Harley's arraignment.
And at this arraignment, you told the court a lie. Is that correct?
Could you repeat your question?
Yes, at Harley's arraignment, you told the court a lie. Is that correct?
I told the court a little white lie.
In court today, you described deliberately misleading the judge as a little white lie.
Objection, Your Honor, argumentative.
Overruled. It's cross-examination.
At the time of the arraignment, Harley was homeless. He did not have a permanent address, so I gave my address.
I'm not asking about what your rationale was at the time, but rather, both in 2016 and right now in court today, you described deliberately misleading a judge as a little white lie. Yes or no?
That is correct.
Okay. Now, let's discuss this lie. So you say the rationale for your lie was that you needed the court to believe you and Harley were living together. Is that correct?
Well, at the time, I was vouching for him, and he did not have an address. And the judge asked me for one, so I had to give mine.
Right. To answer my question, the rationale was that you needed the court to believe you and Harley were living together. Yes or no?
Yes.
Okay. And so, if, as you said on direct examination, Harley was living in apartment 110, I would assume that the lie you told the court was that you lived with Harley at apartment 110. Is that correct?
I don't understand your question.
Did you tell the court that you lived with Harley at apartment 110?
No.
No. What you told the court was that Harley lived with you on Civics Avenue. Is that correct?
That is correct.
After all, you say this version of the story was just stretching the truth. Is that correct?
That's correct. What would you do? I really had no other option at the time.
Your Honor,
Just answer the question, please, and don't ask the attorney what he would do. Go ahead.
thank you, Your Honor. Can you please strike the latter part?
The latter portion of that answer is stricken.
Thank you. After all, you say that Harley did, in fact, keep clothes in your apartment. Is that correct?
That's correct.
Harley received mail at your apartment.
Yes, he received some mail.
Kept his sculptures at your apartment, correct?
Yes.
In fact, you say Mr. Davison spent a significant amount of time in your apartment, correct?
Yes, he is my fiance.
And so he did spend a significant amount of time.
Correct.
He even stayed over many nights, right?
That's true.
And you're aware that the arraignment was not the only time that Harley told a public agency he lived at your address, is that correct?
I'm not aware of how many times he said that.
Well, you're aware that he also told the probation department that he was residing with you, is that correct?
Yes.
So you would agree with me then that Harley Davison, on multiple occasions, told government agencies he was living with you, correct?
That's correct.
Thank you, Your Honor. Nothing further.
Any redirect?
Yes, Your Honor. May I proceed?
Yes, you may.
How did your statements at arraignment not contradict to your testimony today?
At the time of the arraignment, Harley had not moved in with his aunt yet. He only moved in about a month later.
And where's he been living since then?
He's been living in apartment 110 on 12634 West Huron Street.
Thank you. I have no further questions.
All right, thank you. You may step down.
Thank you.
All right, the petitioner may call their next witness.
Your Honor, the petitioner calls Harley Davison to the stand.
Mr. Fox. Your Honor, the witness is deemed to have been sworn.
Thank you.
May I proceed, Your Honor?
Yes, you may.
Good morning, Mr. Davidson.
Good morning.
Please introduce yourself for the court.
I am Harley Davidson.
And where do you live?
I live at 12634 West Huron Street, apartment 110 in Gotham.
And who, if anyone, do you live with?
I don't live with anyone currently. I used to live with my great aunt, Barbara Stone. She died in March of last year.
So how long have you lived in this apartment?
I moved in February 1st, 2016, so a little over 3 years now.
And where did you live before that?
Various places around the city of Gotham.
So then why did you move in with your aunt?
Both of my parents died in 2015. Aunt Barbara was my family. She was getting older. She was 93. And she had some health issues, so I moved in to help with her care. And moving in with her provided me with a chance to find a permanent home.
What was your relationship like?
We were family. We were very close. I cared a lot for her. She cared a lot for me.
Did you spend time anywhere else?
I did. For 2 months in 2016, I was on Rikers Island, and then occasionally I would go and visit my fiancée, Sage Whisker.
So now what happened after your aunt died?
I found a copy of a document that she had submitted to the DHPD. That's the housing authority that manages our apartment.
Your Honor, permission to approach opposing counsel with the document?
Yes.
May I approach the bench, Your Honor?
Yes, you may.
May I have this marked as petitioner's one for identification?
Petitioners number 1 marked for identification, Your Honor.
Thank you.
May I have this given to your witness? Your Honor?
Yes, you may.
Let the record reflect that I'm showing the witness who has been marked as petitioner's one. Do you recognize this document, Ms. Davidson?
I do. It's a document I found after my aunt died.
And how do you recognize it?
It's the same document, and Aunt Barbara's signature is here on the back page.
And it's the sworn statement, right?
It is.
And it's a true and accurate copy of the document you found in your apartment?
Objection meeting.
Just laying foundation, Your Honor.
Overruled, just laying foundation, I agree.
So this is a true and accurate copy of the document you found?
It is.
Your Honor, at this time I offer petitioner's one into evidence.
May I see that, Mr. Bailiff, Mr. Clerk? Thank you. Any objection?
Yes, Your Honor. I object on the grounds of hearsay.
Yeah.
May I be heard, Your Honor?
Yes, Ms. Moore, I'm curious why you feel that this is not hearsay.
Your Honor, this falls in an exception to the hearsay rule. Under Rule 403, this goes to the state of mind of the declarant, Barbara Stone, who intended for my client to remain in the apartment.
Well, Barbara Stone is deceased, correct?
Yes, Your Honor.
And this exhibit, number 1, it certainly doesn't include a statement against her interest, does it?
No, Your Honor.
So it's a little bit concerning because it's signed by someone who is deceased, and it certainly is an out-of-court statement. Did you want to be heard further on your objection, counsel?
Yes, Your Honor. This can only go towards the state of mind of the declarant, which is Barbara Stone, so to have Harley Davidson testify to this is not appropriate.
May I be heard, Your Honor?
Yes.
This goes to lay foundation for my client's subsequent actions. Upon finding this document, it's what led him to believe that he could remain in the apartment, and is why he then filed for succession to the apartment.
May I respond?
Yes, you may.
The purpose that this document is being used for does not go towards its admissibility.
You know, I take a rather liberal approach to evidence, but I certainly am concerned about Exhibit 1 because it is a sworn statement from someone who is deceased, and it doesn't purport to contain any information that I would consider, going against Barbara Stone, the declarant. So at this time, I'm going to sustain the objection.
Yes.
So, Mr. Davidson, upon finding this document, what, if anything, did you do next?
I noticed with this document that I could potentially qualify as a successor.
Objection, hearsay. The witness is including the contents of the document that has not been entered into evidence.
Respect, may I be heard, Your Honor?
Yes.
This is not so much for the truth as to show why my client did what he did to lay foundation for his subsequent actions.
He can certainly testify as to what he did after he saw this document. I'm not allowing the contents in, but you can ask him what he did after he found it without getting into the content. So the objection is overruled.
So what did you do next?
So I noticed that I could potentially be a successor to Department 110, so I decided to follow it up by writing a
Objection,
letter.
hearsay. Once again, this is omitting the content.
I'm going to sustain the objection. You can testify as to what you did, but don't talk about the content of what is in Exhibit 1. What did you do?
Okay. I followed it up by writing a letter to the DHPD informing them that I would be filing for succession rights.
And did you do anything else?
I went down to the DHPD offices and filled out the application for succession to Department 110.
Did they grant you this application?
They did not.
And how did they notify you?
They sent me a letter informing me that they had denied me succession to Department 110.
Permission to approach opposing counsel with the document?
Yes.
Permission to approach the bench, Your Honor?
Yes, you may.
May I have this marked as petitioner's proof for identification?
Yes.
Petition number 2, marked for identification.
Did the witness have this document? Thank you. So do you recognize this document, Mr. Davidson?
I do. It's the document that DHPD sent to me.
And how do you recognize it?
It's written on department letterhead and it's addressed to me.
Your Honor, at this time I offer this document into evidence.
Is that document the letter dated May 16?
Your Honor, would you like the courtesy copy? It is.
Thank you. Okay. Any objection?
No, Your Honor.
Petitioner Exhibit 2 is received.
So which address, Mr. Davidson, did they send this document to, this letter?
They sent it to the address they claimed I didn't even live at, apartment number 110.
Permission to retrieve the document from the witness? So now referring to this letter, Your Honor, referring to the letter, would you like a courtesy copy of it?
I have a courtesy copy, thank you.
So according to this letter, their decision was made after careful consideration. Let's look at that. When, if ever, did they visit your apartment?
Never.
Did they ever interview you?
No.
Ever give you any opportunity to provide your view of the facts?
Not once.
Permission to approach the bench with the document?
Yes.
So now back to your aunt. Who, if anyone else, provided care for her?
Other than me, she had a nurse called Riverside.
Did you have any opportunity to observe the interactions between the nurse and your aunt?
I did. Nurse Ebb took advantage of my aunt. She would often leave early at full pay or take money from my aunt.
Did you
How
do
is
any-
this relevant, counsel? Is the nurse on trial here today?
Yes, Your Honor. Subject to connection, this goes to the bias that Rivers Ebb has towards my client.
I'll allow it.
What did, if anything, did you do about this when you noticed her taking advantage of your aunt?
I confronted the nurse Ebb, and it seemed to me like after that we never got along very well.
Do you know Finley Adams?
I do.
How so?
Miss Adams is my next door neighbor. She lives in apartment 109. She was there when I moved in, and we talked often while I was there.
And do you know Tatum Neal?
I did.
How so?
Officer Neal was my probation officer from May of 2016 through May of 2018.
When, if ever, during that 2-year period, did he visit your apartment?
Never.
Thank you. I have no further questions.
Cross-examination?
Yes, sir. Good afternoon, Mr. Wisner. My name is Cecilia Bauer, and I'll be asking you a few questions today. You say that you spend long stretches of time with your fiancée, correct?
Occasionally.
Okay. In January of 2016, you attended an arraignment, yes?
Yes.
And at the arraignment, you indicated to the court that your place of residence was with Miss Wisner at Civics Avenue, correct?
I did. I was homeless at that point, and the court needed an address, and I didn't have one, so the most reasonable one to give was that of Sage.
Your Honor, I ask that you strike everything after yes is non-responsive to the question.
Overruled.
Yes, Your Honor. Yes or no, at the arraignment, did you indicate to the court that your place of residence was with Miss Wisner?
Yes.
Okay. Now, she vouched for you, correct?
She did.
And this was the first instance in which you provided Miss Wisner's address as your place of residence, correct?
It was.
Just to clarify, Miss Wisner is today here in court, testifying on your behalf, isn't she?
She is.
A few months later, you were asked to provide an address to the probation department, correct?
That's correct.
And you once again indicated that your place of residence was with Miss Wisner, right?
I did.
You received mail at this address.
Some.
You kept personal items there?
Yeah, I kept a few clothes there for when I would stay over with Sage.
Clothes and sculptures, correct?
Yes, I do my work over in the basement of Sage's building.
And you say the reason for this deception is you were concerned the probation department would have doubts with you living around elderly people, correct?
Yes,
Okay. So you reviewed your aunt's death certificate, yes?
I did.
May I approach the bench?
Yes.
May I have this marked as Respondent's Exhibit A for identification purposes?
Yes, you may.
Respondents A, marked for identification.
Thank you. May I approach the witness?
Yes.
I am now handing you what has been marked as Respondent's Exhibit A. Can you identify this document?
This is my aunt's death certificate.
Who filled this document out?
The funeral director did.
Didn't you fill this document out?
I did not.
The top section lists your name, correct?
It does, but I never filled it out.
What was that answer?
It does have my name on it, but I did not fill that out.
All right.
You did not complete the top part of the section of this document.
I did
Objection,
not.
Your Honor, this has been asked and answered. The witness clearly stated that he did not fill this document out.
Sustained. He did say, I think twice now, that he did not fill it out, the top.
In your previously sworn testimony, you say that you did fill this document out, though, don't you?
I did not.
May I have 1 moment, Your Honor?
Yes.
May I approach the bench?
Yes.
May I have this marked as Respondent's Exhibit B for identification purposes?
Yes, you may.
Respondents B, marked for identification.
Thank you.
Is that a B as in boy or D as in dog?
B.
B, thank you.
May I approach the witness?
Yes, you may.
I am now handing you what's been marked as Respondent's Exhibit B. Can you identify this document?
It is my affidavit.
Is that your signature at the bottom?
It is.
Is there a date on the document?
September 7th, 2018.
Is this a true and accurate copy?
Yes, it is.
Okay, I direct your attention to paragraph 16. Can you please read it silent to yourself and then look up when you've finished? I'll ask you the question once again. Did you not give Ms. Weisner's address? Did you not give information on this death certificate?
I did not fill the death certificate out, no.
Okay, did you not make the statement when reviewing the death certificate, I noticed that I had mistakenly given Sage's address as my address to the funeral home that prepared the certificate?
Objection, Your Honor. Reading from a document, not an evidence.
May I respond, Your Honor? May I be heard?
Yes.
This is this witness's own words.
The thing is that the first time around, Ms. Byer, you asked if it seemed to me that you asked if he filled in the beginning section of the death certificate, and now you've changed your question a little bit and asked if he gave information that was contained in the death certificate, and they were really two separate questions. And you are currently reading from a portion of a document that is not in evidence. So what did you want to tell me about that?
Yes, Your Honor. So this is this witness's affidavit, so it's their own words. So I'm simply asking if this is a statement that they had made in the past.
Well, you really can't read from a document that's not in evidence. You can always admit a certain portion of it for the limited purpose of impeachment.
Yes, sir.
But I'd point out to you that you did ask two separate questions here, so I'm going to sustain the objection that you're not allowed to read from a document that's not in evidence, but I'll allow you to rephrase and perhaps be a little bit repetitious with the witness if you feel you need to. So objection is sustained.
Move to strike, Your Honor.
Well, whatever answer was given, yes, will be stricken.
Yes, sir. Mr. Wisner, did you provide information to the funeral home that prepared that death certificate?
I did.
Okay. Your Honor, I now move to enter Respondent's Exhibit A into evidence. May I approach the witness?
Yes, you may.
I will now show opposing counsel.
Any objection to receiving Respondent A in evidence?
Yes, Your Honor. As my client relayed information to the funeral home, who then filled this out, this is hearsay within hearsay. I object to this document being moved into evidence.
May I respond, Your Honor?
Yes.
This falls under the hearsay exception of party opponent since this information came directly from Mr. Wisner.
Well, you know, there's a lot of information in Exhibit A, the affidavit of Harley Davidson. Mr. Davison is obviously here present in the courtroom testifying. I'm not going to receive the entire affidavit of Mr. Davison. If there's a portion of it that you, just a moment, if there's a portion of it that you're offering for some purpose, I may receive that.
I am not offering the affidavit into evidence. I'm entering Respondent's Exhibit A.
Oh, the death certificate, got it. And what did you want to say with respect to the death certificate?
So, Mr. Davison provided an address to the funeral home, who then filled out this document. Therefore, it's hearsay within hearsay, and I object.
Well, it is hearsay. I'll give you that. What did you want to say, if anything, Ms. Byer?
It falls under the hearsay exception of party opponent since this information came directly from Mr. Wisner.
I'm not so sure.
Mr. Davison, sorry, excuse me.
Yeah, I'm not so sure it falls under that exception. In some respects, couldn't it be argued that it's a business record?
Yes, Your Honor.
What do you
it's
think of that?
regularly kept within the funeral home that prepared the certificate.
We clearly don't have a witness from the funeral home. It's also appears to be an official document, official documents regarding births, deaths. Did you want to say anything else about whether that document should come in, Ms. Moore?
Yes, Your Honor. I just request that counsel lay more foundation with this witness regarding this document.
Well, under the circumstances, based upon what I've heard, I will receive Respondent A over objection.
Yes, Your Honor. So on this document, you gave Ms. Wisner's address as your address, correct?
I didn't give it on the document. I gave it to the funeral director.
Okay, but you did give this address, correct?
Yes, because after my aunt died, I was dealing with so many different emotions that I accidentally gave Sage's address.
I didn't ask your rationale, yes or no, you gave this address?
Yes.
Okay. So you provided this information in 3 separate instances, yes or no?
I did.
Thank you. Nothing further, Your Honor.
Thank you. Any redirect?
Yes, Your Honor.
Go ahead.
First, permission to return this document to the bench.
Yes.
So, Mr. Davidson, why did you provide Sage Wisner's address to the funeral home?
After my aunt died, I was so torn up that I accidentally gave Sage's address.
Thank you. I have no further questions, Your Honor.
All right, thank you. You may step down, sir. Does the petitioner have any other witnesses?
The petitioner calls Finley Adams to the stand.
All right, thank you.
Step into the box. Your Honor, the witness is deemed to have been sworn.
Thank you.
May I proceed?
Yes, you may.
Good morning, Ms. Adams.
Good morning.
Could you introduce yourself to the court?
My name is Finley Adams and I am 81 years young.
Ms. Adams, where do you live?
I live at 12634 West Huron Street in apartment 109.
How long have you lived in that apartment?
I moved in back in 1965, so it's been 54 years now.
Could you describe your apartment to the court?
It has certainly aged alongside me.
Could you explain that for the court?
Oh, the AC doesn't work and the heating doesn't either, and the pipes leak as well.
What, if anything, did you do about this?
Well, you know, I informed the department of these problems.
Were you aware of anything that they did to improve your apartment?
Everything's so broken.
Are you familiar with Barbara Stone?
Babs, yes, I certainly am.
How are you familiar with her?
We were neighbors and good friends. She lived right across the hallway in apartment 110.
Does she still live in that apartment?
No, she passed away last March at once.
And did she live alone?
No, she had a nephew called Harley Davidson who lived with her.
Were you aware when Harley Davidson moved into the apartment?
Yes, I saw him move his things in 2016.
Did you get to know him while he was at the apartment?
I did, yes.
And what did you observe about his relationship with Aunt Barbara?
Well, they got along quite well, and Babs preferred his help.
Objection, Your Honor, speculation.
What was the last thing you said?
That Babs preferred his help around the apartment.
All right, overruled.
Who, if anyone else, was regularly at the apartment?
Rivers Ebb.
Who is she?
She was a nurse, Babs' nurse, who would come by.
Did you observe her relationship with Aunt Barbara?
I did. She was a little snoopy at first.
Objection, Your Honor. In proper opinion, the witness is characterizing Rivers Ebb as a snoopy person.
All right, sustained. The witness should talk about her personal observations, what she saw, heard, not make characterizations, please.
Are you familiar with Blake Wards?
Yes, I am.
How so?
He was an investigator who came and interviewed me.
How was that interview?
Oh, he was extremely rude and polite. And
Objection, Your Honor. In proper opinion.
I'll allow it. I mean, I think you can observe and sense rudeness, so I'll allow it.
Yes, Your Honor. Would you like to continue, Ms. Adams?
yes, and he refused to listen to what I was telling him.
From your observations, where did you observe that Harley Davidson lived?
Oh, he lived in apartment 110 with Barbara Stone.
Thank you. I have no further questions.
All right, cross-examination?
Yes, Your Honor. Good morning.
Good morning.
My name is Catherine Yang, and I'll be asking you a few questions today. Now, Ms. Adams, you live in apartment number 109 of your rent-controlled building, correct?
That is correct.
And like you mentioned on direct, your apartment is managed by the DHPD, correct?
It is.
And like you mentioned on direct, you filed a lot of complaints over the years against the DHPD, haven't you?
I have.
And just some of them are your pipes still leak, your windows still stick, and your AC only works in the winter, correct?
That is right.
And you are also familiar with DHPD investigator Blake Wards, correct?
I am.
And in the past,
past, you've referred to Investigator Wards as a flatfoot, haven't you?
I have, yes.
A knitting hammer?
Yes.
A glorified meter maid even.
Yes.
You've even stated that it would be better yet if Wards and other members of the DHPD were fired, correct?
That's right.
Now you live across the hall from Barbara Stone's old place, apartment number 110, correct?
I live in 109.
And this is across the hall from Barbara Stone's place.
Oh, yes. 110.
And you've lived across the hall from her for the past 50 years, correct?
That is right, yes.
And so you're familiar with Miss Stone's nephew, Harley Davison?
I am.
And you're quite fond of Harley, wouldn't you say?
Well, you know, we talk. I mean, we're not best friends, not.
Which you used to gossip with Harley in the hall when he was around, correct?
Yes, like.
Objection relevance? May I respond now?
Yes.
I'm simply establishing the relationship between this witness and the petitioner today, Harley Davison.
Between this witness and the petitioner?
Yes.
Repeat your question for me.
You used to chat with Harley in the hall when he was around.
Overruled. You may answer.
Yes, we would chat.
And during one of your chats with him, you asked him, quote, "Are you back for another visit?" Correct?
That was a joke, yes.
I'm not asking about the nature of it. I'm simply asking whether or not these were your words. Are you back for another visit? Yes or no?
As a joke, they were my words.
Now, just to clarify, Ms. Adams, this particular joke came after Harley was away from the apartment for an entire month, correct?
I am not exactly sure, but sure. Yes, it must have been something like that.
In your previously sworn testimony, you do say that this comment came after he was gone for an entire month, right?
Yes, for a time.
Now, when Harley did stay at Miss Stone's place, it's in the room that you refer to as the spare room, correct?
Yes, that was in Barbara's apartment. You know, it was made up of 2 rooms.
I'm simply asking you whether or not the term you used was spare room, yes or no?
Yes.
And Miss Stone actually informed the neighbors that Harley was only a temporary guest, correct?
Objection, hearsay.
Your Honor, may I be heard?
Yes.
Since in this case the declarant is Miss Stone, who is deceased, and the statement contradicts her expressed proprietary interest for Harley to inherit the apartment, it falls under the unavailable declarant exception to the hearsay rule.
Counsel.
407.
I don't believe this goes against her interest.
Repeat that question again.
Miss Stone informed the neighbors that Harley was only a temporary guest.
I'm going to sustain the objection. Would you just move up closer to that microphone, please?
Yes, Your Honor.
All right, the objection is sustained.
Thank you. Now, you yourself have stated that Harley would be away from the apartment for long stretches of time, correct?
He would.
Now, in your previously sworn testimony, you said that, quote, "It is great that Harley will be living in the apartment permanently now," correct?
Yes, he would.
Objection, this is a statement from a document that has not been marked into evidence.
Overruled. You may answer.
Yes, he.
And this statement comes from your affidavit, which you filled out in 2018, correct?
I believe so.
But Mr. Davison is alleged to have moved into apartment 110 back in 2016, correct?
He did, that's right.
So when you made the statement that it is great that Harley will be living in the apartment permanently now, this is 2 years after the date you claim Harley moved into the apartment, correct?
Could you repeat that question?
Yes, I'm simply asking about the time frame. When you stated that it is great that Harley will be living in the apartment permanently now, this is 2 years after 2016 when you claim Harley moved in, correct?
Yes, he's lived in the apartment since 2016.
Your Honor, I ask that you strike the latter portion of the witness's testimony for being non-responsive.
Overruled. The answer will stand.
All right. So this was 2 years after the date that you claim Harley moved in.
I gave my affidavit 2 years after 2016, yes.
Thank you, Your Honor. No further questions.
All right. Any redirect?
Yes, Your Honor. Why did you call Blake Wards those names?
Well, because he was refused to listen to me and accused me of lying, and that's no way to treat a respectable, old, innocent sugar cube like me.
Does your view of Blake Wards affect your testimony today?
No.
I have no further questions.
All right. Thank you. You may step down.
Thank you.
Does the petitioner have any other witnesses?
The petitioner rests, Your Honor.
All right. Thank you. Is the respondent ready to proceed?
Yes, we are, Your Honor.
All right. You may call your first witness.
Your Honor, the respondent calls Investigator Blake Wards to the stand.
Step to the box. Your Honor, the witness is deemed to have been sworn.
Thank you.
May I proceed?
Yes, you may.
Good afternoon. Can you please introduce yourself to the court?
Good afternoon. I'm Senior Investigator Blake Wards.
Investigator Wards, what is your educational background?
I graduated from the John Jay College of Criminal Justice in 1995 with my bachelor's degree in criminal justice, and I then attended the New Jersey State Police Academy in 1996.
And Investigator Wards, what is your occupational history?
In 1997, I began working with the New York Department of Public Safety as a police officer, where I worked for approximately 10 years, and then I began my career at the Department of Housing Preservation and Development here in Gotham.
Now, what does your job with the DHPD entail?
Well, the job of the DHPD is to provide and maintain affordable housing for the citizens of Gotham, and my job in particular is to conduct housing investigations.
What is the function of a housing investigation?
A housing investigation is used to determine whether or not a citizen is eligible to take control of our taxpayer-funded rent-controlled apartments.
All right. Now, are you familiar with the petitioner in today's proceeding, Harley Davidson?
I am. I reviewed his request to take ownership of apartment 110, and I came to the conclusion that he failed to meet the eligibility requirements.
Why wasn't Davidson eligible?
Pursuant to Gotham City Regulation 28 RC, Section 302, P3 and N, a tenant must have resided with the previous tenant, in this case was Barbara Stone, for a minimum of 2 years before attempting to take control.
Objection, Your Honor, goes to a legal conclusion.
Overruled.
I came to the conclusion that Harley failed to meet this requirement.
How did you come to this conclusion?
Well, based on my investigation, which included visits to the apartment as well as interviews with witnesses and physical evidence as well.
All right, let's start with your visit to the apartment. Based on this, what, if anything, did you learn?
Although there was some personal belonging of Harley's in the apartment, the evidence was overwhelmingly indicative of Harley being a visitor rather than a resident to the apartment, which was what was reflected in DHPD records.
Objection, Your Honor. This is an invention of fact. It's nowhere mentioned in the fact pattern that this witness visited Miss Stone's apartment.
May I respond, Your Honor?
Yes.
This witness clearly states that he interviewed a witness at the apartment building, makes observations about the belongings in the room. Clearly he visited.
Can you point to a page in the record for me in his statement where he says that?
Yes, Your Honor.
Thank you.
Your Honor, in paragraph 7, he describes his observations of the apartment, including the clothing stored at the apartment and the key to the apartment. In paragraph 9, he mentions an interview he conducted with somebody who we've heard today lives at the apartment, which is Finley Adams.
All right, just give me a moment. Well, I'm looking at paragraph 7 of this witness's statement, and it infers that this witness knew information about clothing being stored in the apartment. It says, while Davison may have had a key to the apartment, may have had some mail delivered to the apartment, and may have had some clothing in the apartment, and not a permanent resident. I don't see anything implicit in that paragraph that this witness was in the apartment and made these specific observations. So certainly the witness can testify as to what's contained in his statement, but on the issue of whether he visited that apartment. I'm going to sustain it unless you can show me something else in this affidavit to say that he was physically present at any time in that apartment.
Yes, Your Honor. Paragraph 9, he interviews Finley Adams, who, as we heard earlier today, lives at the apartment building.
Your Honor, if he interviewed Finley Adams, he may have been in the apartment building, but not necessarily Ms. Stone's apartment.
And yes, Your Honor, we are not offering anything other than the fact that he did, in fact, visit the apartment.
That he visited the apartment building?
Yes.
All right, I will allow that, overruled.
Thank you, Your Honor. Mr. Morris, did you get to finish your answer?
No, could you please repeat the question?
Sure. Based on what you saw at the apartment, what did you learn about it?
Well, again, as I said, although Harley did have some personal belongings at the apartment, the evidence was overwhelmingly indicative of Harley being a visitor to the apartment rather than a resident, which was what was reflected in the HPD records.
All right. Now, you mentioned interviews earlier. Were any of these conducted while you were at the apartment building?
Yes, I attempted to interview Mrs. Finley Adams.
Attempted?
Well, yes, I simply asked her whether or not Mr. Harley Davidson resided across the hall from her.
How did she react to this?
She became unresponsive and uncooperative, and after trying to ascertain a simple yes or no, she terminated the interview.
So were you able to learn anything useful from this interview?
Unfortunately, I was not able to. I was forced to abandon this line of inquiry in pursuit of other leads.
What other leads did you pursue?
I was aware that Ms. Stone had a part-time nurse, River Zeb, whom I was able to contact through her agency and also set up an interview with.
Okay. Now, after your interview with River Zeb, chronologically, what, if anything, did you conclude?
After my interview with River Zeb, I came to the conclusion that Harley was certainly not a resident of apartment 110 and would be gone for weeks to even months at a time from the apartment.
Okay. Now, you also mentioned physical evidence earlier. To which physical evidence were you referring?
Well, as senior investigator, I had access to the lease on the apartment, as well as Davison's probation record, and even Ms. Barbara Stone's death certificate.
Okay, let's start with the lease on the apartment. May I approach the bench?
Yes.
May I have this document marked as Respondent's Exhibit C for identification?
Yes, you may.
Respondents C, marked for identification.
Thank you. May I approach the witness?
Yes.
I'm now handing this been marked for identification as Respondent's Exhibit C.
Thank you.
Can you please identify that document?
Yes, this is the lease agreement between Ms. Barbara Stone and the Department of Housing Preservation and Development.
Your Honor, I'm willing to stipulate this document into evidence.
Were you about to offer it?
Yes, I was. I appreciate it.
Counsel's clairvoyant. Okay. Defense Exhibit C is received.
But I would request to see the document.
Yes, Your Honor. I was about to show her. May I approach the witness?
Yes.
Thank you. Thank you. Thank you. May I approach again?
Yes.
Respondent's Exhibit C.
Thank you.
So, Investigator Wards, what, if anything, did you learn from the lease on the apartment?
The lease on the apartment informed me that Miss Barbara Stone's name was the only one listed as a resident on the lease, and that Miss Harley Davidson's name was nowhere on the lease at all.
Okay, now let's discuss the probation records you mentioned. After viewing these documents, what, if any, conclusion did you come to?
Probation records again reflected that Miss Harley Davidson resided with her fiance, Sage Weisner, at 1154 Civics Avenue, which is also her mailing address.
All right, now let's talk about the death certificate. Your Honor, may I approach the bench to retrieve Respondent's Exhibit A?
Yes.
Thank you. May I approach the witness?
Yes.
Respondent's Exhibit A. Investigator Wards, can you remind the court what this document is?
Yes, this is Miss Barbara Stone's death certificate.
And who was it that provided the information contained in this document?
The informant was Harley Davidson.
Where can we find this information?
Box 13A.
Thank you. Now, directing your attention to box 13C, what, if anything, did you learn from this?
Box 13C informed me that 11254 Civics Avenue was the address that Harley provided on this document, which is also the address of her fiancé, Sage Weisner, as well as her mailing address.
So, Investigator Wards, how did the physical evidence as a whole influence the course of your investigation?
The physical evidence simply corroborated my observations and interviews.
What did this all lead you to conclude?
It all led me to conclude that there was an insufficient amount of evidence for Harley having resided in apartment 110, and that there was an overwhelming amount of evidence for Harley having resided elsewhere, namely with Sage Weisner at 11254. And this led me to conclude that Harley was ineligible to take control.
Objection, Your Honor. This goes to a legal conclusion, whether or not Davison would have qualified.
May I respond, Your Honor?
Yes.
This is admissible for two reasons. First, the central issue is not whether his conclusion was correct or not, but whether there was a rational basis. And second, he's not stating in court today this is true, but rather stating what he concluded in the past.
Did you want to say anything else, counsel?
It goes to a legal conclusion because his observations determined what the department's decision was. So it goes to whether or not the decision was arbitrary and capricious.
Well, as I recall the question, it was after reviewing all of the physical evidence, what conclusions did you draw? And I don't think that he's giving legal conclusions here yet, but if you feel that it happens, if you feel that it's happening at any time later, you can object again. But based upon the question that I heard and the answer that was being given, overruled.
Did you get a chance to finish your answer?
No. So based on the evidence saying that she didn't reside in apartment 110, as well as the evidence that said she resided elsewhere, namely 11254 with her fiance, I came to the conclusion that she was ineligible to take control of the apartment.
Thank you, Your Honor. Nothing further.
Cross-examination?
Yes, Your Honor. Your Honor, I request that Respondent's Exhibit A be shown to the witness.
He still has it.
On this death certificate, it has an address for Harley Davison, correct?
Yes, it does.
And above that address, it says mailing address, correct?
Yes.
And the lease agreement, the date on the lease agreement is from 1968, correct?
Yes, it has not been updated since then.
Your Honor, I request that the documents be returned to the bench.
All right.
Thank you.
On direct, you stated you were a senior investigator, correct?
Yes, I am.
So you'd agree with me that it's important to be objective in an investigation, right?
Well, yes, of course.
Yet you have a particularly no opinion of Harley Davison, don't you?
Objection. Calls for an opinion explicitly.
Overruled. This is cross-examination. You may answer.
Relatively, I would say.
You called him a leech on society, didn't you?
For attempting to take...
Just answer the question.
Yes.
And a 39-year-old juvenile?
I called her a juvenile.
And didn't you say he wasn't the sort of person the DHPD wants to house? Weren't these your words?
Because she doesn't meet the qualifications. Yes.
Were these your words?
Yes, because he doesn't meet the qualifications.
There's a process for determining who qualifies for rent control department, right?
Yes, there is.
And it's important that this process is fair, right?
Yes.
And to be fair, it has to be consistent,
Yes.
objective,
Yes.
and thorough.
Yes.
Determinations have to be based on facts, correct?
Which they are.
So they have to be based on facts?
Yes, which they are.
And facts are determined through testimonial evidence,
The facts are determined on various things.
but partly through testimonial evidence.
Yes.
And also partly through documentary evidence, right?
Yes.
And then there's regulations that control how you assess the facts, aren't there?
Yes.
And you're familiar with these regulations?
Of course, I'm a senior investigator.
So turning to testimonial evidence, you mentioned interviewing Cindy Adams, right?
Yes, I did.
And you said on direct that she hesitated when she responded to you, weren't these your words?
Yes, she hesitated and was uncooperative.
So you pressed her, didn't you?
Yes, I was simply trying to ascertain an answer.
Is that a yes?
As I just said, yes.
She's an elderly woman, isn't she?
Yes, I believe so.
In her 80s?
Objection, Your Honor. The state of Ms. Finley Adams has nothing to do with whether it was rational or not to question her.
Well, the pending question is in her 80s, so overruled. I'll allow you to answer that.
She is 80 years old, yes.
And you stated that you may have pressed her too hard, correct?
I was simply trying to ascertain a simple yes or no answer.
So you stated that you may have pressed her too hard, right?
Yes, that's what I stated.
And after you interviewed her, you investigated her, didn't you?
No, I didn't.
You pulled her file back at the DHPD, correct?
Yes, she mentioned complaints and I wanted to see how they were resolved.
So you decided to take her testimony with a grain of salt, weren't these your words?
Well, first off, I had no testimony of hers, but yes.
But these were your words to take her testimony with a grain of salt, yes or no?
The limited testimony that I had, yes.
You also mentioned interviewing Rivers Ebb, right?
Yes.
Are you aware of the hours Rivers Ebb spent at Miss Stone's apartment?
No.
Would it surprise you to know it was from 12 to 2?
Objection, Your Honor. This witness has been sequestered. He cannot be hearing information that is neither contained within his fact pattern nor any other source of evidence which he has available to him.
Did you want to respond, counsel?
Yes, Your Honor. I was just asking if you would be surprised to know that she's only there for 2 hours in the middle of the day, as he relied on her testimony.
I'm going to sustain the objection.
You also mentioned interviewing Tatum Neal, right?
No.
You also interviewed Tatum Neal, didn't you?
No, I didn't.
It's your testimony today that you didn't interview Tatum Neal?
No, Tatum provided me with some information, but I never interviewed.
Tatum Neal is a personal friend of yours, isn't he?
We've met through work.
And he was also Harley Davidson's probation officer, right?
Yes, she was.
And it was Miss Tatum Neal who told you that Harley Davidson resided with Miss Stone, right?
Yes.
Going to documentary evidence, are you aware that Miss Stone submitted a notification to the department?
Objection, Your Honor. This document has been kept out of evidence. I don't see how a line of questioning relating to this document would be relevant.
Well, I'm not sure where it's going, so overruled at this time. Would you repeat the question and let the witness answer it?
Are you aware that Miss Stone submitted a notification to the department?
Yes, I am.
And this notification is kept in the DHPD files, isn't it?
Yes, it is.
Going to Gotham City's regulations, are you aware that their regulations provide that that family member must only be in the apartment for 183 days out of the year to qualify for permanent residency?
To be a resident, that's what you must meet, yes.
And Gotham City regulations also provide that a court-ordered absence is not considered a break in residency. Right?
Objection, Your Honor. What counsel is referring to is not coming from the regulations that are automatically taken judicial notice of. They're not within the statute. Rather, they're within the document, I believe it was Petitioner's Exhibit 1, which is kept out of evidence on the second page.
Overruled. If the witness knows the answer, I will allow him to testify. Do you need the question repeated for you?
Yes, please.
Go ahead.
Are you aware that a court-ordered absence isn't considered a break in residency?
It depends on the court-ordered absence.
But this is the DHPD's regulation, isn't it?
No, not necessarily.
But it is one of the things that they consider, right?
Yes.
Now, Gotham City Regulations 203P3 also provide that once a family member requests to become a new tenant, they shall be asked to provide information of their residency, correct?
Yes, I believe so.
You never asked Harley Davidson for any information, did you?
She had submitted everything she needed to me already, so no, I didn't need to.
You didn't ask her to provide anything, correct?
Since I had the information I needed, I had no need to.
So you didn't speak with him, did you?
No, I had his application.
So you didn't speak with him.
As I just said, no, I had his application.
You didn't even visit his apartment, did you?
As I stated, I observed things in his
Just answer
apartment.
the question, please.
I observed things in his apartment, so I believe I had to be there.
But you didn't go to Miss Stone's apartment, correct?
I observed things in the apartment, so I assume I had to have gone.
Did you state that in your affidavit?
I state that I observed things in the apartment, yes.
Did you interview those close to him, like Sage Wisner?
I interviewed Miss Finley Adams.
Did you interview Sage Wisner?
No, not to.
You didn't go to her place of residency either, did you?
No, I had no need to.
Thank you. I have no further questions.
Any redirect?
Briefly, Your Honor. Investigator Wards, when you said that Harley Davidson was a leech on society, or not someone we want in our municipal housing, what were you referring to?
I was referring to the actions that she's currently taking to take advantage of a government body that's trying to help people. And she's someone that doesn't qualify, and because of she's trying to take advantage of...
Objection, Your Honor. Improper opinion.
May I respond, Your Honor?
Well, yes, you may.
This is the same conclusion that was admitted earlier on direct examination, that you
Your Honor.
deemed her ineligible.
Your Honor, my objection is to the fact that he stated that Harley Davidson is trying to take advantage of the housing department.
For the latter portion of that response, I will sustain the objection.
Move to strike that phrase.
Yes, that would be stricken.
Yes,
Thank you,
Your
Your
Honor.
Honor.
Now, can you clarify whether Finley Adams ever specified her residence for Harley Davidson to you?
No, she didn't give me any relevant information.
Okay. And now, finally, it seems like there's some confusion about whether you had information from Harley Davidson. Did you?
Yes, of course. I had multiple pieces of evidence as well as her application.
Thank you. No further questions.
All right, you may step down, sir.
Thank you.
The respondent may call their next witness.
The respondent calls Tatum Neal to the stand.
You step into the box. Your Honor, the witness is deemed to have been sworn.
Thank you.
May I proceed? Good morning. Can you please introduce yourself to the court?
Yes, my name is Tatum Neal. I'm 53 years old and I live in Gotham, Nirvana.
What is your current occupation?
I'm a probation officer with the Gotham City Department where I've been for nearly 3 decades.
What are your responsibilities as a probation officer at TAL?
Well, for the last 28 years, I've had hundreds of probationers. The job basically boils down to making sure they show up once a month for their appointments and make their scheduled payments and stay out of trouble. It's pretty straightforward.
So are you familiar with the petitioner, Harley Davidson?
Yes, I was his probation officer from April 1st, 2016 to May 25th, 2018.
What were the terms of his probation?
He was to visit me the first Monday of every month and pay a $25 fee.
Did he adhere to these requirements?
Yeah, he made every meeting and payment at my office as scheduled.
And so, did you ever feel the need to go to Mr. Davidson's apartment?
No, I didn't. As I said, Davidson was making his scheduled appointments and payments, so to do so would be completely unnecessary.
Were there any other reasons you never checked up on him?
Davidson was convicted of a single count of shoplifting. All of his other track record consists of minor crimes and violations. It's not like he had a pattern of theft.
To the best of your knowledge, where did Davidson reside while on probation?
With his fiancée, Sage Wisner, at 11254 Civics Avenue, apartment 10.
How did you know this to be true?
For several reasons. First, this is the address that Davidson and Wisner gave the court and the one the court gave us. Secondly, no mail was ever returned. And thirdly, under Penal Law 6510, Davidson is required...
Excuse me, do you have an objection?
Yes, Your Honor. To the portion that the court provided this address, that would be hearsay to the probation department.
Did you want to respond to that, counsel?
Yes, Your Honor. There's no specific statement being offered.
Well, ordinarily, I would have the court reporter read back that answer, but anything provided to this witness by court would be hearsay, so that portion of the response is stricken, but the rest of it may stand. When you have an objection, make sure you shout out objection for me, because you can interrupt the witness if you need to, because I'm looking down a lot at my notes. So that portion of the objection is sustained.
Thank you.
Go ahead.
Yes. Did you finish your answer?
I didn't. Under Penal Law 6510, Davidson is required to notify me of any change in address, and he never did, so I took that to mean that his residence was with his fiancée.
Now, at any point, did you ever share this information with any other agency?
Yeah, this is what I told Blake Wards from DHPD.
Thank you, Your Honor. Nothing further.
Any cross?
Yes, Your Honor.
Okay.
May I proceed?
Yes, you may.
Good morning, Ms. Neal. So you've been a probation officer for 28 years, correct?
Yes.
You received a degree in criminal justice, didn't you?
Yes.
So you're a veteran law enforcement officer, correct?
I'd say so.
As a veteran law enforcement officer, you'd be familiar with what constitutes sound investigatory practices, wouldn't you?
Perhaps.
It's important to be thorough, right?
Sure.
Objective,
Yeah.
Keep your voice up, please.
Yeah.
professional,
Yes.
and there's a dispute over where Davison resided, correct?
Yes.
You've told Mr. Ward's information regarding this, didn't you?
Yes, I gave Mr. Ward's the knowledge of the probationary department at the time.
You told him that Davison resided with Miss Wisner, didn't you?
Yes, that is the information that we had.
Are you aware that he relied on your testimony?
No.
Would it surprise you that he did?
Well, this is information we have on record, so no.
But it was an assumption that you told him, correct?
No.
Objection relevance.
Your Honor, this is entirely relevant, as the department interviewed this witness and relied on her testimony, and if what she gave him was an assumption, it's entirely relevant.
May I be heard, Your Honor?
Yes.
Speculating as to future events and reactions that wards would have had to information that wasn't given is irrelevant.
Overruled. The answer will stand.
Your Honor, before I proceed, may I have this witness's affidavit marked for identification purposes only?
Yes.
What is this?
Petitioner's 4. Petitioner's 3. Petitioner's 3.
Petitioners 3, mark for identification.
So, Ms. Neal, in your affidavit, do you recall saying that this was an assumption? You thought it was fair to assume Davison resided with Ms. Wisner? Yes or no?
It is my assumption. I never say what wards asked me. Wards may have asked me what the knowledge of the probationary department was.
That's not my question. Merely what you told him. Was it an assumption, yes or no?
It was my personal assumption, yes. I
Thank you.
assumed he was right question.
You never confirmed where Davison lived, did you?
I never had a reason to, as I said, incorrect.
You never visited Sage Wisner's apartment, yes or no?
As I said, no.
You never interviewed Sage Wisner, yes or no?
No, I never had a reason to interview my clients. No.
In fact, you said that as long as these ex-cons show up at your office, that's good enough for you, correct?
That's what they're supposed to do, yes.
Now, on direct, you said that your job is straightforward, didn't you?
It's pretty straightforward, yes.
But you still stated in your affidavit that you think you're overworked, right?
Yeah, sometimes.
And underpaid?
Yeah.
That's why you can't wait to retire, can you?
Yeah, I can't wait to retire.
You feel you're entitled to the good life, correct?
Well, after proudly serving Gotham for right on 30 years, I would say so.
You stated in your affidavit that for now you can handle it's basically come down to paper pushing and coffee patches. Were those your words, yes or no?
Well, the job has been very exciting as of late.
Now, you were Davison's probation officer between 2016 and 2018, correct?
Yes, I was.
And during this time, he made every appointment, didn't he? Yes or no?
Yes.
Every month?
Yes.
For 2 years?
Yes.
Paid every fee?
Yes.
Faithfully?
Yes.
Yet you still think he plays the system, don't you?
I say that with regards to a petty larceny charge.
Ma'am, that's not my question. Do you think he plays the system? Yes or no?
Objection, this is an improper opinion by a non-expert.
This goes to the credible. I'm sorry.
Sometimes you don't even have to ask to be heard because you may win a ruling. So overruled. You can repeat the question.
You think he plays the system, don't you? Yes or no?
Yes, with regards to a petty larceny charge.
You also think he's a manipulator? Yes or no? Those were your words in regards to him.
Yes, it was.
So you were more than happy to provide Mr. Ward with information regarding Mr. Davison, weren't you?
Yes, I was happy to provide Ward with the only address we had on file for Davison.
Thank you. And Mr. Ward was a friend of yours, right?
No.
But you're familiar enough with him to reference yourselves as Batman and Robin, right?
We live in Gotham City.
So you reference yourselves, yes or no?
I'm sorry, could you repeat the question?
Yes or no? You reference yourselves as Batman and Robin.
Yes, as coworkers, we do joke around.
Now, you don't know where Davison resided before probation, do you?
No, I didn't know Davison before then.
You don't know where he resides after probation either, yes or no?
No, my Ben Davidson is no longer my probation.
Thank you. I have no further questions, Your Honor.
Any redirect?
Briefly, Your Honor. So there's been some confusion over assumptions and information you told wards. Can you please clarify what exactly you told investigator wards?
I told Investigator Wards the only address we had on file for Davidson, which was 11254 Civic Avenue.
And was any of the information you told wards affected by any relationship you developed towards Harley Davidson?
Objection, Your Honor, the leading question.
Overruled.
Absolutely not.
Thank you. Nothing further.
You may step down. Respondent may call the next witness.
Your Honor, the respondent now calls Rivers Ebb to the stand.
Step in the box. Your Honor, the witness is deemed to have been sworn.
Thank you.
May I proceed?
Yes.
Good morning. Can you please introduce yourself to the court?
Hello, my name is Rivers Ebb. I'm 49 years old and I live in the city of Gotham.
And what is your current occupation, Ms. Ebb?
I've been a nurse for the Tender Home Care Agency for over 20 years. We provide daily home visits to elderly or infirm patients, and we try to maintain our patients' independence and keep them out of nursing homes.
And what is your connection to today's case?
Well, for over 3 years, I was Barbara Stone's personal nurse. I was at her apartment every single day, weekends and holidays, to ensure that she had proper medication, nutrition, and company.
And what was your relationship with your patient, Ms. Stone, like?
Well, we had a professional caretaker-patient relationship. However, Ms. Stone was a very kind woman with few family members, and she expressed some affection for me.
How so?
Well, like I said, I was at her apartment every day, and occasionally she would give me these little gifts as tokens of appreciation. And to respect her dignity and preserve our relationship, I would accept.
And did you ever ask for any of these little gifts?
No, of course not. I would never.
Now, are you familiar with the petitioner today, Mr. Harley Davidson?
Yes, I believe he is Ms. Stone's nephew.
And what observations, if any, have you made regarding the relationship between your patient, Ms. Stone, and her nephew, Harley?
Well, Harley was rarely around the apartment, and when he was, he'd constantly be asking Ms. Stone for money, and the two of them would argue. It was never really my place to interfere, though.
And how often did you see Harley Davidson at Ms. Stone's apartment?
Very rarely. And on occasions that he would come by, he'd always be in and out, and there'd be weeks and months at a time where I just wouldn't see him at all, despite the fact that I was at the apartment every single day.
Now, Ms. Ebb, could you please remind the court, how long did you work for Ms. Stone?
I worked for her for about 3 years.
And during this time, what, if anything, did you observe regarding whether or not Harley Davidson moved into the apartment?
I made no observations to that effect.
And what did Ms. Stone have to say about Harley's residence?
She said that Harley did not live with her.
Objection, hearsay. May I respond, Your Honor?
Yeah, why is that not hearsay?
Because it falls under the Rule 407 exception, unavailable declarant, since Ms. Stone is deceased.
Well, she is unavailable. What did you want to say about that, counsel?
It's not against Ms. Stone's interests.
The 407 states that it is admissible, meaning a statement of an unavailable witness, if a reasonable person in the decedent's position would have made the statement only if the declarant believed it to be true, because when the statement was made, it was so contrary to the declarant. I don't think that that comes in under 407.
May I be heard, Your Honor?
Yes.
We assert that this does go against the declarant Ms. Stone's interest, since she has expressed that she would like her nephew to inherit her apartment.
And where is that in evidence?
It's contained within the fact pattern of the case, Your Honor.
Well, it's contained in a document that I didn't receive in evidence. Isn't that true? Did I receive the document where she stated that she wanted her nephew to succeed her?
I believe no.
And who objected to that? Which side objected to that? Do you remember?
I believe there was a response.
Right. So I'm going to sustain that objection.
Yes, Your Honor. Move to strike.
Yeah, that's stricken.
Now, are you familiar with DHPD investigator Blake Lawrence?
Yes. Ms. Stone, unfortunately, passed away last year, and at one point, Investigator Lawrence reached out to me to inquire about Harley's residential status.
And what did you tell him?
Well, I confirmed to him that I was at the apartment every single day, and I told him that Harley was rarely around, and that I saw no sign that Harley had moved in during my tenure. I just told him what I knew, that Harley Davidson was a temporary visitor and not a permanent resident.
Thank you, Your Honor. Nothing further.
Cross-examination?
Yes, Your Honor. Good morning. You stated on direct you received gifts from Miss Stone, didn't you?
Occasionally, she would offer me little gifts.
You didn't make any effort to decline these gifts, did you?
Well, no, I wanted to respect her independence.
Yet your employer discourages the acceptance of gifts, don't they?
Objection, Your Honor. This comes from the THA Code of Ethics, which is a document that has not yet been entered into evidence.
Well, if the witness has knowledge of the policy, separate and apart from the document, she can certainly testify to it, so overruled.
Yes, Your Honor. So your employer discourages the acceptance of gifts, yes or no?
It discourages, but allows us to accept gifts that are voluntarily given.
So is that a yes that they discourage it?
Yes.
And your agency has a code of ethics, doesn't it?
It does.
Your Honor, may I approach the bench to have a document marked for identification?
Yes.
That's 4. Your Honor, petitioners 4 marked for identification.
Thank you.
The code of ethics states that your employer is worried about impropriety, right?
Objection, Your Honor. This is quoting from the document that has not yet been entered into.
Yeah, if you want to use the document and read from it, it needs to be in evidence.
Respectfully, I'm using it for impeachment purposes, Your Honor.
Yes, what did you want to say?
May I be heard? Regardless of what it's being used for, it still must be entered into evidence prior to any quotations.
Well, not necessarily. Ask the question again, please.
Your employer is worried about actual impropriety, right?
If you have personal knowledge to answer that question, you may answer it.
Beyond the Code of Ethics, I have no knowledge of that.
Your Honor, may I have the code of ethics marked into evidence as petitioners 4?
You're offering the, what exhibit is that?
Petitioners 4. The code of ethics.
Is there any objection to petitioners 4?
Yes, Your Honor. We object to this document being entered on the grounds of hearsay.
And how is it relevant, counsel?
I'm going to use it for impeachment purposes.
So we have a trial here regarding whether or not what Gotham City did was reasonable, and now we're going to get into the code of ethics of an independent nursing facility, are we?
I'm trying to impeach the credibility of this witness, Your Honor.
Well, I will allow it for the limited purposes of impeachment. Go ahead.
Petitioners 4 in evidence.
Now, the code of ethics states that your employer is worried about actual impropriety, doesn't it?
Could I have the code in front of me, please?
You may. May I approach the bench?
Thank you.
All right, can you answer that question now?
Yes. So, is this worried about impropriety or the appearance of impropriety?
Right, as you stated, it's also worried about just the appearance, right?
Yes.
And with regards to the acceptance of gifts, you found it necessary to state, "To heck with caution, I want what's coming to me." Were those your words?
Well, as I had such an established relationship with my patient, I didn't see the need to practice excessive caution. So yes, I said that.
Could the witness return those documents to the bench? Thank you. Your employer charged Ms. Stone $35 an hour, didn't they?
They did.
And that was for 2 hours a day
Yes.
and 7 days a week.
Yes.
So you were paid around $280 a week?
No, I only get $20 of that $35, so I would be paid around $1,400 a week from Miss Stone.
That was $1,400 a year, right?
A week. I'm paid hourly, $20 an hour.
$20 an hour for 2 hours a day, right?
Yes.
So that would be $40 a day.
Yes.
For 7 days a week,
Yes.
that would be $280 a week.
Objection, Your Honor, relevance?
Well, I always give some leeway on cross-examination, so overruled, you may answer.
Yes, Your Honor.
Sorry about that. Yes.
And around $14,000 a year, right?
Yes.
And over the 3 years that you were Miss Stone's nurse, you were paid around $45,000?
Something like that.
And yet you still stated in your affidavit that I'm not well paid. Weren't those your words?
$45,000 a year, it's hard to live on.
Objection, Your Honor, relevance. How this witness perceives her income has no bearing on today's Article 70 proceeding about the DHPD and Harley Davidson.
Well, I agree with you on that, but it may go to bias on the part of the witness, so I will allow it.
Yes, Your Honor. But $45,000 was just for Miss Stone, wasn't it?
It was.
And you did state that you're not well paid?
Yes.
Now, just to be clear, you were only at the apartment for 2 hours a day, right?
I was.
And you left early sometimes, didn't you?
Occasionally, Miss Stone would dismiss me early. Yes.
So at best, you were at the apartment for 2 hours a day?
Like I said before, yes.
But you have no idea what happened the rest of the day at the apartment, do you?
Well, no. I would make observations around the apartment, and I would speak to Miss Stone.
So you don't have any knowledge of what happened the rest of the day, do you?
I do. I would make observations of the apartment, and I would speak to my patient.
But you were not there at night, were you?
No.
So you have no direct personal knowledge of where Harley normally slept, do you?
Besides what I've heard from Miss Stone, I don't have any direct knowledge.
You don't know where he ate his meals either, do you?
No.
You don't know where he received any of his mail?
I was not privy to that, no.
And you don't like Harley, do you?
Well, unfortunately, I saw him taking advantage of the patient under my care, so we weren't particularly fond of each other.
You view him as a lowlife, don't you?
He was taking advantage of my patient.
You view him as a lowlife, is that a yes?
I have said that, yes.
And you think he doesn't deserve the apartment, don't you?
I didn't express any of my opinions with words, but I personally, I guess, do not.
And you called Harley Davidson a no-good, two-faced piece of garbage with a lousy attitude. Were those your words, yes or no?
Those were my words. Like I said, we didn't have a fond relationship.
Your Honor, I have no further questions.
Any redirect?
Brief, Your Honor. May I proceed?
Yes.
Now, Miss Ed, there was some confusion over the nature of the gifts given to you by Miss Stone. Could you please clarify this?
Yes.
Well, what confusion?
As to whether or not she was permitted to accept these gifts.
All right, well, there's no need for you to begin a question that there was some confusion, because I'm not so sure there was confusion, so rephrase that question.
Yes, Your Honor. Could you please clarify the nature of the gifts?
Well, Ms. Stone gave them to me voluntarily, and though our policy discourages us to accept, it allows us. So to protect our relationship, I would accept.
What was your relationship with the petitioner Harley Davidson like?
I saw him taking advantage of a patient under my care, and I took issue with it.
Objection, speculation.
Overruled. It's her personal knowledge.
How does your personal income affect your testimony today in court?
Not at all.
Thank you, Your Honor. Nothing further.
You may step down.
Thank you.
Your Honor, at this time, the respondent rests.
All right, thank you. Would either side request 5 minutes to get ready for your closings?
Yes, please, Your Honor.
All right, we'll take a 5-minute break. Thank you.
Thank you, Your Honor.
Court's in recess, 5 minutes. All rise. Going to recess. This court is in session.
Be seated, everyone. All right, the court is ready for summations.
Yes, Your Honor. May it please the court. Your Honor, today we heard the story of a routine housing investigation conducted by investigator Blake Wars, which reached a rational conclusion. Remember, Wars' job was to determine whether the Harley-Davidson was eligible to take over the lease on apartment 110, 12634 West Huron Street, which would require that he had lived in the apartment for the 2 years prior to the death of the previous tenant, his late great aunt, Miss Barbara Stone. Your Honor, there are 3 key facts that we would like you to recall from today's proceeding. First, it was Harley who in January of 2016, at her arraignment, told the court of law that she resided with Sage Weiser at 11254 Civics Avenue. Second, it was Harley who a few months later told the probation department that she was residing with Sage Weiser at 11254 Civics Avenue. And third, it was Harley who once again provided the same address, 11254 Civics Avenue, on the death certificate to the funeral home. Harley Davidson, on 3 separate occasions, to 3 different government agencies over the span of 2 years, consistently said that her address was 11254 Civics Avenue. Now, Your Honor, let's recall the legal circumstances of today's proceeding. Because it is not a trial, rather an Article 78 proceeding, the petitioner has the burden to prove by a preponderance of the evidence that the DHP's decision was arbitrary and capricious. Pursuant to the case of Peckham v. Calagaro and all other relevant precedents in the state of New York, this means that so long as the agency had a rational basis for its decision, a court of law may not interfere with the decision, even if it would have come to a different one itself. What this means for today's case is that, well, Your Honor, we do argue that Harley Davidson did not live in apartment 110, even if you were to believe that he did live there. The DHPD's decision must stand so long as it had some rational basis. Now, the facts have indicated that Ward's investigation was rational in every manner. First, let's recall the January 2016 arraignment when Mr. Davidson told the court of law that he resided with Sage Wisner at Civics Avenue. Now, Ms. Wisner and Mr. Davidson have come to court today with the excuse that they were merely lying. So this poses a couple of potential issues. First, if they really were lying, this would only indicate a pattern of deception. Remember, we heard from Mr. Wisner's testimony just how much money the 2 of them will save by moving into the apartment. And given the strong motivation to take over the lease, combined with the supposed history of lying to the courts to get what they want, and Mr. Wisner's statement in court today that deliberately misleading a judge, she just considers that to be a little white lie. The testimony must not be given too much weight in court today. Now, the other potential issue is that they could have been not, and that even as early as January 2016, Mr. Davidson was already living with Ms. Wisner. See, this version of the story is actually quite consistent with reality, or just stretching the truth, in Ms. Wisner's words. After all, we heard from her testimony that Harley Davidson kept art supplies at her apartment, that he kept his clothes there, received his mail there, spent a significant amount of time in the apartment, and even stayed over many nights. Now, we anticipate the petitioner to harp on the timing of the arraignment, pointing out that it occurred in January of 2016, which is before Mr. Davidson alleged to have moved into apartment 110. But, Your Honor, this does not vitiate the point of our argument, which is that the arraignment constitutes evidence which fits into a consistent pattern that the DHPD rationally interpreted to mean that Ms. Davidson lived on Civics Avenue. See, this is because Davidson next told the probation department that he was living with Mr. Wisner. Once again, he came to court with the excuse that he was merely lying. But, Your Honor, remember, we know from Ms. Wisner's testimony just how much of a presence he had at her apartment, and we heard Officer Tatum Neal testify today, Harley's probation officer. And she said that no mail sent to the apartment was ever returned, and that Davidson would have been required to submit a change of address had he moved into apartment 110. Therefore, there was no reason for the government to be suspicious. And, Your Honor, we must remember that because of the legal framework we are operating under in today's proceeding, the central issue is the rationality of Ward's decision. Therefore, our analysis must be based on what Ward knew at the time. And sure, it cannot be expected to somehow read Mr. Davidson's mind and discern that he had been lying to multiple government agencies for a variety of reasons years before he conducted his investigation.
Was there ever any sworn testimony taken before Gotham City arrived at its legal decision?
Sworn testimony from whom, Your Honor?
From anyone, was there ever a hearing conducted by Gotham City?
No, Your Honor. A hearing was not required because in this case, Harley-Davidson submitted all the applicable forms. There are certain forms which the regulations stipulate may be involved in the hearing, such as tax returns, motor vehicle documents, but these did not apply to Mr. Davidson because he did not have any of these documents. Now, furthermore, Your Honor, because the DHPD's decision must be based on what wards knew at the time, ultimately, it was rational for the DHPD to conclude from Mr. Davidson supplying his address at Civics Avenue to multiple government agencies, that meant that he lived on Civics Avenue. Now, the petitioner today has harped on the lack of consideration which they believe Mr. Wards gave to some of the witnesses they brought to court today. However, in all of these cases, his decision was rational. We must analyze his efforts under the framework of our precedents. The case of Persix v. Merchants Insurance established that a court of law must defer to an administrative agency's rational interpretations in its own area of expertise. The DHPD must be granted such deference in how its senior housing investigator weighs evidence. In the case of Harley-Davidson, Wards made clear today that he did in fact consider his input, that the application and supporting documentation sent by Davidson was the very basis for his investigation. His job was to determine if the statements were true. Now, in the case of Ms. Wisner, Your Honor, Mr. Wards is a senior investigator with 10 years of experience. Surely he would know that fiancés are generally not the most reliable witnesses, being of course biased and likely to lie. What we heard from Ms. Weiser today certainly indicates that this was a rational determination. And finally, as for Finley Adams, Wards made very clear today that Adams simply never indicated to him where Davidson resided, so there was no relevant testimony for him to either accept or to discard. Now, alternatively, the petitioner has suggested that Wards' bias played an impact in his decision, pointing to statements he made that Davidson was not someone we want in our municipal housing. But Your Honor, Investigator Wards has made very clear why we don't want Davidson in the housing. He's not eligible. The bias, as a petitioner would say, is merely a smokescreen. Now, furthermore, Your Honor, while the petitioner has provided witnesses with clear biases and histories of lying on behalf of Harley to the court system, a more reliable eyewitness was the Stone's nurse, Rivers Ebb. Well, yes, she was part-time. Rivers Ebb was at that apartment every single day of the year, weekends and holidays, speaking to Miss Stone and observing what was going on in the apartment. Based on these observations and conversations, surely she'd be able to discern whether or not Miss Stone had another person living with her in the apartment for a duration of 3 years. And surely she would know if somebody was moving into the apartment midway through her tenure, as Mr. Davidson alleges. Therefore, the contributions of Rivers Ebb simply corroborate with the physical evidence it already demonstrated. Harley-Davidson did not live in apartment 110. Now, Your Honor, one last piece of physical evidence to consider is the death certificate of Miss Stone. On this death certificate, Harley-Davidson, yet again, told yet another agency, the funeral home, that the address that was his was 11254 Civics Avenue. Now, the petitioner may point out that this address was a mailing address. However, it still remains a strong indicator of residency. See, this is because the apartment that was listed on this form was that of an apartment in which we know Mr. Davidson spent a significant amount of time, an apartment which he gave as his place of residence to multiple other government agencies. Therefore, it was still rational of the DHPD to interpret this document as confirmation that Mr. Davidson did not live in apartment 110. So, Your Honor, it's become clear today that Harley-Davidson was not a resident of his aunt's apartment for the 2 years required to take over the lease. And remember, Your Honor, that even if you were to believe that Mr. Davidson did live there, this still wouldn't be enough for the petitioner to have met their burden of proving by a preponderance of the evidence that the DHPD's decision lacked a rational basis. See, in a few moments, the petitioner may try to distract you by theorizing about how to justify Harley's contrived excuses, or overlook the bias and lies of Sage Weisner, or calculate to the very second the amount of time Rivers Ebb spent and did not spend in apartment 110. But, Your Honor, we, the respondent, would just like you to recall 3 simple and undisputed facts in today's proceeding. Harley gave a court of law, Civics Avenue, as her address. Harley gave probation, Civics Avenue, as her address, and Harley listed Civics Avenue as her address for the funeral home on the death certificate. Pursuant to the Gotham City regulations which govern today's case, when determining where an applicant resides, specification of any other address to a public agency is an explicitly mentioned class of evidence demonstrating residency. Your Honor, under the strong deference our law affords to administrative agencies, the DHPD would have a rational basis for its decision if someone were to make one statement of residence at another address. Harley made 3. Therefore, Your Honor, based on this fact, and based on all the evidence that we've heard today, we ask that you uphold the DHPD's rational decision. Thank you.
All right, thank you, counsel. Is the petitioner ready to sum up?
Yes, Your Honor. May it please the Court? As we stated at the beginning, the willful blindness of the Housing Department deprived my client of the apartment he was entitled to. Did the Housing Department act reasonably in doing this? No. Did they act based on established facts? No. They acted in an arbitrary and capricious manner to reach a predetermined outcome because they did not like my client. Any deference this court owed to a determination by the department was forfeited when the department based its determination on the biased investigation of Blake Wards, whose cherry-picking of evidence and disregard of due process makes mockery of this standard. Let's examine his investigation in detail. What was Ward's outlook at the beginning of his investigation? You heard Wards admit today, thinking my client was a juvenile, a leech on society, and not deserving of a rent-controlled apartment. Your Honor, that is not the best place to start an investigation that is supposed to be even-handed and get to the facts of the matter. Did Investigator Ward speak with my client? No. You heard Ward admit today that he never solicited any information my client could have provided showing his actual residency. He never asked Davison to provide any evidence during the course of his investigation. Instead, Investigator Ward simply decided that Davison was just not the sort of person the DHPD wants to house.
But didn't he also rely on documentary evidence and prior testimonial evidence by the client as to where he was living? I understand he didn't speak to him, but he did rely on some documentary evidence, didn't he?
Your Honor, all the department had from my client was the letter he addressed to them saying he would fill out the application and the application itself.
What about the probation records?
He received that information from Tatum Neal. So during his investigation, he simply decided that Harley Davison wasn't the sort of person the DHPD wants to house. And he directed the rest of his investigation to bolstering that conclusion. So if Davison had resided with Miss Wisner, as Ward's claimed, did Ward's interview Wisner? No. You heard Ward's testify today that he decided that Wisner would lie. Had he spoken with her, he would have heard the same thing you heard Wisner testify to today. Davison visited her apartment, but never moved in. Instead, you heard how Investigator Wards got information from Tatum Neal, a witness willing to provide evidence that supported Ward's theory. However, you heard today that the statements that Ms. Neal provided were assumptions, and she had no first-hand knowledge of where my client actually lived because she never confirmed Davison's address. Officer Wards also managed to find Rivers Ebb, another witness willing to claim that my client didn't live in his apartment. Your Honor, you heard today that at best, Rivers Ebb spent 2 hours in the middle of the day in Miss Stone's apartment. You heard her admit that she had no idea what happened in the apartment the rest of the day, and had no idea where my client actually slept. You also heard that Investigator Wards interviewed Finley Adams, my client's neighbor, intimidating her in the process, and of course, discrediting her testimony when he found out she knew my client lived in the apartment. You heard Blake Wards today admit that he decided to take her testimony with a grain of salt. In fact, you heard that Investigator Wards investigated Finley Adams after he interviewed her to find an excuse to discredit her testimony. What about the documentary evidence Wards had available? Your Honor, more assumptions. You heard how Investigator Wards ignored the sworn notarized statement Miss Stone submitted to the department. Again today, the respondents ignored this document that was from the DHPD that Miss Stone filled out. Likewise, he ignored the initial application of my client. Instead, you heard that Investigator Wards gave credit to a death certificate, not filled out by my client, but by a funeral home director. Ironically, however, you heard today that the department chose to communicate its decision to my client in a letter addressed to the very apartment in which they claimed he never lived. Turning to the law, it is clear the department's decision prohibited my client from any semblance of due process. Gotham City's own regulations provide that once a family member requests to become a new tenant, they shall be asked to provide information about their residency. Yet you heard today that at no time was my client ever asked for input prior to the final determination being made. Today, the respondent pointed out the visits Davison made to Wisner's apartment. Your Honor, according to Gotham City's own regulations, these visits are irrelevant. You heard Blake Wards admit today that Gotham City regulations provide that a family member must only be at the apartment for 183 days out of the year to qualify for permanent residency. Likewise, the time Harley-Davidson spent on Rikers Island is irrelevant. As you heard today, Gotham City's regulations don't consider a court-ordered absence a breach in residency. While it is true that my client has the burden of proof under an Article 78 proceeding, courts have held that this burden is met and that a determination must be reversed when the determination relies on the testimony of compromised witnesses and ignores contrary facts and alternative rationales. In Wards versus City of Long Beach, the court overturned a determination that relied primarily on the observations of the fact finder and on a witness with personal animus against the petitioner. Similarly today, the only witnesses Wards credited were Tatum Neal, whose statements to Wards were assumptions, and Rivers Ebb, who admittedly disliked my client. Your Honor, based on the bias exhibited by Blake Wards and who he decided to interview, which testimonies he credited, and which documents he reviewed, it is clear the department's determination lacked any semblance of due process. Add in the fact that the process they followed violated their own regulations, and it is clear that their decision was both arbitrary and capricious. And accordingly, I ask that you find in favor of my client. Thank you.
Thank you.
While the judge is doing her final tally of the score, just want to tell you a little about the judge. I'm Oliver Young, and I chair the mock trial subcommittee that prepares the case materials each year. And just and your judge today has been Judge May D'Agostino. She is a United States District Court judge for the Northern District of New York, having been appointed to the court in 2011. She received her undergraduate degree from Siena College, where she was a member of the women's basketball team. She received her law degree from Syracuse University College of Law, and she is an adjunct professor at Albany Law School, where she teaches medical malpractice. The reputation on the bench is that of being tough and demanding, but extremely fair. And you've observed that today. So Judge D'Agostino, thank you very much again for judging our final match in the Albany finals. I think a lot of On behalf of the New York State Bar Association and the New York Bar Foundation, I want to congratulate all 8 teams that competed over the past couple of days here in the Albany finals. It's not easy getting to Albany. It's a lot of work to get here, and it's tough to get to the final match. But all 8 teams, in my opinion, acquitted themselves very well over the past 2 days. While only one team will be able to claim victory in the 2019 Albany Finals, all 8 teams are champions. So, round of applause, all 8 teams.
All right, I would just like to take a 5-minute recess so I can check my math and someone else can check my math. And then when I come in, I'll have a few words to say, and then I will very quickly announce the prevailing team. So we stand in recess for approximately 5 minutes.
Thank you. All right. Recess, the court is in session.
Be seated, everyone. So every year I tell my staff that this is an event that I love and I despise. I love it because the level of the talent in the room is so amazing. And I don't like it because I have to vote for a prevailing party here, a prevailing side. And I am going to announce who prevailed in just a second, but, you know, I don't know who your coaches are, if they're attorneys, and I have no idea as to what schools that you come from, but the level of proficiency here is truly amazing. I'm in the courtroom almost every day, and I have lawyers who have been practicing for 5 and 6 years who don't demonstrate the skill level that I saw here. And I think all of the witnesses were very compelling and fun, too. And as keyed up as you all are for a final trial, you all maintained your sense of humor, and you have a very good ability to react extemporaneously, which is good because it demonstrates that you're not just getting up and reading lines that you memorized. You are acting extemporaneously, and I like to see that. And the civility is something that brings joy to my heart because oftentimes in the real world, I have to remind attorneys to read the New York Rules of Civility. But everybody here during this trial had such a nice demeanor, an amazing command for the facts, an amazing command for the rules of evidence. And so I salute both sides, and I hope that both sides leave with their heads held high, because judging is very subjective. You could have another judge here who could see it a different way. This is not a sport where you cross a finish line, is it? It is totally subjective. So in any case, by the smallest of margins, I found in favor of the respondent defendant today. Congratulations. Congratulations again to the top two teams in the state. And I would say to both teams and coaches and witnesses that if your schools would ever like to spend a few hours with me, watch some of my proceedings, all you need to do is call. I'll make that happen. I hope we have some budding attorneys here. I hope that you realize what a wonderful profession it is to be an attorney at Counselor at Law. I congratulate your coaches, well-coached teams, your parents, and whoever else is here to support you. Job well done. Thank you.